Mike, we get calls all the time from people who say, I've been charged, or my family member has been charged with felon with a firearm. What is that?
Well, in California, Penal Code Section 12021 precludes certain individuals from possessing firearms. Simply put, there's three categories. One, convicted drug offenders. Two, convicted felons. And three, certain misdemeanor convictions, normally in the area of domestic violence, domestic discord, battery, and with misdemeanors, it's normally a 10-year gun ban.
So you have these sort of categories of people who in the state of California are not allowed to use, own, or possess firearms.
That's correct. And as far as the certain misdemeanor ones, if people look at our website, we have a detailed list of every misdemeanor that is applicable where there's a gun restriction.
What if it's if the gun is found maybe not on my person but in my house? So let's say I'm a convicted felon. I'm not allowed to have a gun, but I live in a home with my wife, and let's say that she has a gun and it's sort of locked up in a cabinet somewhere. But it's my home. I could have access to it, but it's it's not in my pocket. I'm not carrying it around. The police come and raid the house, they find the gun. Can I be charged with felon with a firearm?
You can. It's one of those, what we call strict liability crimes. If you're a convicted felon, one of the things that you've been told numerous times due to that conviction is you can never possess a firearm. You can't be around the firearm. Now, in the situation as you described, there may be some argument that could be made. For example, if it is registered to the wife, if it is a locked gun safe, and there's evidence that we could bring forth that in fact the defendant or client, the accused, didn't have access to that gun safe. I think that that's a meritorious and a defensible issue. But for the standpoint of being charged, strict liability. If you're a convicted felon and there's a gun in your home, not only will the cops expect the cops and the district attorney to arrest you and file charges.
Does self-defense apply in this situation? I mean, let's say that I'm a convicted felon and I'm caught shooting someone or pointing a gun at someone, and it's a legitimate self-defense. That person was threatening me. Does that matter in that case? Or?
Well, it matters from the standpoint, we could be talking about apples and oranges. You may have a right under that situation and have a valid defense to the assault issue or that issue relative to the shooting. But that doesn't necessarily give you a defense as to the strict liability crime, ex-felon in possession of a firearm. Though, depending on the facts of the case, juries may have a lot of sympathy for you, and you never know what a jury will do. Sometimes they will look at the underlying facts and not convict them on any charges. I'm Mike Scafiddi, a retired police officer and now a criminal defense attorney with Shouse Law Group. If you or a loved one are in trouble and need help, call me.